Welcome to Act 2 of this Are You a Banker two-part mini-series. I hope you have your popcorn at the ready because in this act, the action is really going to kick off. So let the show roll on. A quick summary of what we went through in Act 1 regarding the requirements that are needed to be recognized as a bank or as engaging in banking business. Well, there are three essential requirements. 1. You handle other people's money or value. 2. You conduct deposit, lending, and note issuing functions. And 3, even if you do just one of these functions, you can still be recognized legally as a bank or a banker. So let's now get into it. Are you a banker? No, really, are you a banker? Do you handle other people's money or value? Well, let's think about it. If you have any so-called money, either in cash or coins, or even the electronic money, any sort of central bank currency really, is the cash really yours? I mean, in England, for example, the notes, they are property of the Bank of England. The coins, well, they are property of the Royal Mint. And if you have supposed creditors chasing you for money, then maybe, just maybe, the money you think is yours is not actually yours legally because someone else has a claim to the same property at the same time as you. Then do you conduct deposit, lending, and note issuing functions? Well, if you ever give anything of value to an institution, maybe you give them a government issued ID, for example, to open a bank account, or even maybe as covered in the previous Are You a Person series, you accredit the data from your legal instruments, for example, your birth certificate, to the state administration itself, then you actually do deposit things of value to others. You also do lend money because, well, the money in your bank account is actually a loan to the bank and you become their creditor. And also, you make promissory notes every time that you sign and create a mortgage or any kind of loan instrument. If any of these don't quite make sense to you, then do check out our series, The Truths You Haven't Been Told About Trust, where we do cover this in quite a lot of detail as well, which may bring you more clarity. And lastly, if you do any of these functions that we have discussed, then would you look at that? You are legally recognized as a bank or a banker, and you had no idea. I mean, if you still have any doubt if you are actually legally recognized as a banker, take this for example. If you fail to meet the so-called obligations that you have for whatever reason, you can become bankrupted, and you will either be forced into the legal process of bankruptcy, or you will file this yourself, right? So just think with me for a moment. If you can be put into this process, does this not logically mean that legally you are treated as a banker? I mean, how would it be possible to be bankrupted if you're not legally being recognized as a bank or a banker? The clue is in the terminology and the process itself. But then the question here is, who are you actually banking for? Because it is clearly not for yourself. I mean, it's not for your benefit, because if you have creditors after you, then that is because there is an assumption that you are a banker looking after their property, and all they're doing is making a demand for you to give them their property back, and essentially you are failing to comply. They come to you saying, show me the money, and you're there scratching your head like, I haven't got it. I mean, imagine you went to your bank to take out the money you have in your account, and the bank staff turned around to you and said, no can do, we haven't got it. I'm pretty sure you'd be furious, right? Now, let's just focus on the bankruptcy aspect a little bit more. If you are legally recognized as a banker and you are put into the process of bankruptcy, this will involve the court appointing a trustee in bankruptcy who will handle your affairs because, well, clearly you are not competent enough to handle them yourself. Otherwise, you wouldn't be in the situation in the first place, right? Does this not therefore mean that you are being presumed in law to be a trustee and you are actually an incompetent trustee because you are not giving the creditors the property that they think they are beneficially entitled to? In fact, you are acting so incompetently to the point where the court had to kick you out and appoint a new trustee because, well, you simply cannot be trusted anymore. But hold on a second.
Wait a minute!
Does this not mean that there is a hidden trust relationship? Does this also not mean that the whole process of bankruptcy is entirely enforced in equity only? But hold on a second. If there is a trust relationship and it is hidden, but not for much longer, and this relationship, well, in this relationship, you are being presumed as the trustee, my question is, when did you consent into this role? Because under the UK law, there is no act that states that one has to be forced into this role, right? No one is obligated to be a trustee if they don't consent into it. The only exception to this is where there is fraud or unconscionable behavior involved, in which case equity imposes a constructive trust upon you where your consent is not a requirement at all. So my next question is, did you commit a fraud, or are you wrongfully holding on to property that belongs to someone else? If the answer is no, then how come you are being treated as though you have committed a fraud, or as though you are actually holding on to property that belongs to someone else which you are not entitled to? This is all very suspicious, right? It makes me think. So, seeing as you are presumed as having done something wrong, but you haven't, then all this means is you just have to rebut that presumption with contrary evidence, right? But it also, on the other hand, makes me think, well, there is a presumption in law that one is innocent until proven guilty, right? But how is it that paradoxically, at the same time, you are also presumed and assumed to have done something wrong, either to be acting fraudulently or holding on to someone else's property when you shouldn't have? Hence, you are presumed as trustee, and therefore you are able to be put into the process of bankruptcy in the first place. So, how could this be? I mean, you haven't done anything wrong and you haven't given your consent to be a trustee. Does this actually mean that you're actually the settlor or the beneficiary or both at the same time, but actually you are being presumed as the trustee because you haven't actually expressed who you are in this whole hidden trust relationship? There are only 3 parties to a trust. Let's see who is in which position then, shall we? Okay, so picture the scene. You are in a bankruptcy situation, and a trustee in bankruptcy has been appointed. We need to figure out, who are you in this whole thing exactly? Well, there are only 3 positions, right? The trustee has been taken, so that leaves the settlor and the beneficiary positions. So there we go. Visually, you can see the trustee role is taken. Now, let's think logically about the other 2 positions. So the whole bankruptcy process is actually brought about by the court, right? Yes, it's true that someone can file for bankruptcy, so maybe another company or it's you yourself, but ultimately it will be the court who will have to accept the application and actually start the proceedings. The court also are the ones who appoint the trustee in bankruptcy, so they are acting in the settlor position. However, does the court own your property outrightly? No is the answer. And only one who holds property outrightly or the beneficial title to the property can actually settle it into trust. So what is really happening is that the court is acting as the settler on your behalf, because it is you who owns the property beneficially, right? So only you really could settle it on trust. The court are acting as like the middleman in a way, because they are functioning as the settler, doing what a settler would do, right? Which is to settle the trust and appoint a trustee who then has to figure out which property will become subject to the bankruptcy proceedings. But ultimately, the court does not own the property, you do. So we can see visually now that the settler position is taken by you through the middleman, which is the court. Now, focus will turn to the beneficiary position. So whoever has put you into the bankruptcy is probably going to be putting themselves in the beneficiary position, right? Claiming the beneficial title, so claiming the right to disbursements. But of course, he who claims must prove. So we do need to question, what proof do they have to support their claim to beneficial rights to your property? Because as things are right now, your property is your property. Whichever version of ownership title you have, it doesn't really matter. If you have title to some property, you therefore own it to some degree, depending on which type of title you have. So for someone to now be claiming beneficial title to your property, and we have clearly shown you that you do not have the legal title because that is what the trustee has. The trustee in bankruptcy, they have already been appointed. They have the legal title, not you. So this can only mean you have the beneficial title left. The problem is, someone else is also now claiming that from you, but you really do need to question, at which point did you dispose of your beneficial entitlements to your property to whoever's now claiming against you? Because for them to claim a beneficial title, there must be some sort of agreement in place where you actually agreed with your fully informed consent to give up your beneficial title to your property for their benefit. But where is this evidence? And also, is it in writing or is it just orally? Because oral dispositions of beneficial title to property are not enforceable by law. They have to be in writing. So, where is this evidence of the written disposition of your beneficial entitlements to your own property? Or is this entire situation all a presumption that requires your rebuttal with contrary evidence? So, if the property is yours and you are not the trustee, this means by default you are the sole living beneficiary of your property. And if you did not dispose of your beneficial title to that property to someone else in writing, which was actually signed by you, then how on earth can you actually be put into the bankruptcy process? How can you be bankrupted in the first place? So now you can see visually on the screen, you are the settler and the beneficiary of the hidden trust relationship. So we can see that the only way in which one ends up in this whole situation of bankruptcy in the first place is when you fail to claim your beneficial title in this construed relationship right from the beginning. I mean, if you express this information really early on, then I bet you no one will be trying this process against you, really. Unless, of course, you did sign some sort of agreement to dispose of your beneficial title to the property and in a way that actually is recognized in law and enforced in law as well. If that is the case, then that's a different story altogether, and a story that can get rather complex in of itself. So where do all of the issues arise exactly? Well, they arise when you do not claim your rightful position and title to your own property. And remember, property cannot be void of an owner. This is a really key maxim to know. If there is property, which bear in mind, anything that can be owned is considered property, which includes even just a title to a property, that is property itself. So if there is property and no one is making a claim to it, well, the law actually has a protective device in place for these kinds of situations, and that is the doctrine of Bona Vacantia. When there is property or title to property that doesn't have an identifiable owner or someone who's actually claiming to have that property as part of their possessions, then the property or the right to it will vest to the Crown automatically. This is, of course, until someone with a better claim to the property can actually come along and evidence their right instead, and evidence that their right overrides the right of the Crown. So hopefully you can see that when you do not claim your rights to your very own property, what happens is you are the settler because the property was originally yours in some way. Then you are not the trustee, so you don't have the legal title. So that's half of the ownership gone automatically to the trustee in bankruptcy. Then you fail to claim the beneficial title, the Doctrine of Bona Vacantia will kick in, and this will vest completely to the Crown, and then the Crown will own the beneficial title, which they will dispose of to whoever is claiming against you in the bankruptcy in the first place. Then, in that case, you may as well wave goodbye to the rights and titles to your property because now you are left in a position where you do not have any titles for yourself. Hence, the property has been legally and equitably taken from you because certain information hasn't been put on the record or expressed properly. So this brings us to the end of this two-part mini-series, where we have explored the topics of banking to such a degree that hopefully now you can conclusively answer the question, are you a banker? So let's just look at what we have discussed exactly. Well, we have gone over the law definitions of bank and banking. We've explored the requirements that you need to be considered a bank or a banker. We've shown you how you are legally recognized as a banker. We have gone over bankruptcy as proof that you are legally a banker. We've discussed that there is a presumption of trusteeship based on the very fact that a trustee in bankruptcy gets appointed. We've explored that if you didn't consent into the trustee role, it means it's being imposed upon you under a constructive trust to prevent a wrong. And we've also gone over the proof that you need to claim your beneficial entitlement to your own property and fast when dealing in bankruptcy proceedings. And as we draw to a close, I hope that this series has helped you realize that by law, you are actually indeed recognized and presumed to be a banker. And it is this recognition that is the source of so much confusion and problems in terms of your property and your rights to your own property as well. If this series was helpful for you, helping you see things in a different light, then make sure to leave a like, subscribe to keep updated with us, and share this video with someone else who can also benefit from this knowledge. All of this helps us very much and we do not take your support for granted. Thank you for watching and I will see you in the next one.